condensed version of my normal educational workshop session. I'm going to try to pick a few topics that I've seen from both of my department court claims seem to be more pertinent and more prevalent today. I'll hang around for questions afterward if some of you might be interested in the full service workshop, or you or your staff or anything, or have questions, just let me know. But I'm going to start off with some of the more pertinent topics today, so you can get an idea. Spend a little time on the parental and spousal liability, just because the prevalence of those questions I get from clients almost on a daily basis. And then I'm going to spend some time on wrongful delays, and then basically maybe mention misquoted benefits, but then go on to the net action pre-op. They come up quite a bit, and then also discuss some refund demands and issues with that and PPL claims. So as I go on, if you all have any questions, don't hesitate to stop me, and I will be around for questions after. The two issues I'm going to go over next are more involving something called doctrine of the necessary. It's parental and spousal liability. I know these are more into the self-pay realm, but the questions come up very frequently. I get sometimes daily questions from clients about what to do in these scenarios and who might be liable, and it also helps from time to time, especially in the parental liability case, in working to get the parent's cooperation to get information, say, about health insurance. The question that does come up here, I won't spend a lot of time on it, but it is an important topic. It comes up very frequently. Basically, when a child comes in, somebody under the age of majority, in most states that's under 18, comes in for medical care and treatment. Sometimes this child may live with one parent. The parents might be separated or divorced. In many of these cases, a child lives with one parent as opposed to the other. And the question is, who's liable for this claim? Something that I've seen more and more that our clients have been telling me about that's occurring more frequently. When the parents bring the children in for this medical care and treatment, they tend to not want to sign off on the financial guarantee forms. And they think, hey, if I don't sign on the dotted line, I can't be liable for the child's claim. So don't come and look at me for that. So in this case here, when they get the medical care and treatment, the question is who is liable for that? Can anybody tell me who would be liable if one child lives with one parent, that parent has custody, and the child's brought in for care and treatment? Who's responsible for that? Does the child have insurance? It could be involved, but there could be cases where you're still going to have a copay and deductible. You're going to have cases where you might have an underpayment or a denial, and so you've got some patient responsibility. So, yes, ma'am.
I know the parent as well as the child, and the other agreement I was looking to cover them and everything is between that parent and the other parent. So we'll certainly bill it if you want to pull them in. If you want to.
Right. Okay.
Really say the same thing. Whoever brings it in, hey, or parent,
right.
It's your divorce, bring it up,
Right. Right. That's good. That's definitely one way to look at it. Basically, in this case here, you can look at either. So I know you're going to usually pick one as the guarantor. So if you want to go that route, that's a good way to go. You can pick the route of the parent that brought the child in. If for some reason that parent falls or you're not able to get that parent to pay, you can actually look to the other parent for full payment of that bill because there's a doctrine called joint and several liability. And that means that basically both parents are liable for the medical care or treatment of the child, the minor child. And sometimes they'll come in. I think one person mentioned the divorce decree. I've had them come in and basically wave that around to our client and say, hey, we've got a divorce decree that specifically says here that the other parent is liable for the medical care treatment, so I'm not going to pay it. Well, whoever mentioned that hit the nail on the head. That divorce decree is basically between those two parties. It's not binding on the medical provider. So you can actually look to either one, and if you look to the one who has the decree that says the other one has to pay it, they've got to do that on their own time. Good answers. And the doctrine I mentioned, there's something called the doctrine of necessary. It holds true in almost every state in the country. There's certain things that are looked at as necessary in life, and those are primarily, food, clothing, shelter, medical care, and treatment that are going to be deemed to be necessary. When you're to are given to a minor child, and both parents to be liable for that. And that's important too, not only to know possibly who to go after. You could have a choice of both. Also, it's important because sometimes you just want to get health insurance information. You brought up a good point when you mentioned health insurance. Because sometimes you're going to need to get health insurance information coordination of benefits, accident information, and I found that tends to help the cooperation. Sometimes the parents say, hey, I'm not responsible, so I don't even care to help you. So sometimes this could be a tool and say, hey, you could be responsible for the bill. Sometimes that aids in their cooperation a little bit. Good responses. This same doctrine here, the doctrine of the necessary, also can hold true for spouses. And we've seen the situation a lot. One thing that a lot of our clients have told me about is the spouses have tended to, in many cases, separate their finances, have separate bank accounts, separate credit cards, and things like that. And so here you've got a case where one spouse is treated for medical care, and then you've got a hospital bill that comes out. And again, we can presume that neither one of them, obviously the one that they brought them in, didn't sign the financial guarantee. So who do you think is responsible for that in that case? Good. Here you go. You guys are good. You're good. Jersey actually has some case law on this. Yes, sir? Is there any other where one has also been you could have that. Sometimes you could have possibly a guardianship. You could have a different type of arrangement. Sometimes you could have a contractual relationship. Right. No, in this case, we're presuming that there's no financial guarantee, there's no contract or anything. It's just based on the relationship between the parties. Right. And that's governed in New Jersey. You've got some good case law on it. Basically says that you could be liable. Again, it's that doctrine of necessary. Since medical care is necessary. If one spouse can't pay, you look at the other, or stop the state, as you mentioned. But that's important. This is the majority rule. Many states around the country follow this rule. Other states used to follow different rules. Some states, there's a couple now that still basically uphold that if a spouse doesn't sign the financial guarantee form, they can't be held liable. So it's state-driven, and that's why it's important. You might have people come say here to Atlantic City that live in another state, reside in another state. You might need to look at the law that governs their state to see if that follows the majority rule. Most follow this. There were a few states until recently. One of them is where I'm from in Virginia. I live in Northern Virginia, outside of Washington, D.C. And Virginia used to follow this. They changed it. And the law in some of the minority states used to say if the wife brought the husband in for medical care treatment, if she didn't sign the financial guarantee form, she wasn't liable. But if the husband brought the wife in for medical care and treatment, even if he didn't sign the financial guarantee form, he was on the hook. And that didn't go over well. And we had some husbands who filed suit and said, no way, I'm not going to go for that. And the court agreed. They said that was not constitutional. So I think there might definitely be one state left that follows that. Do you have a question? Yeah. If they're just living together, then in that case, as a general rule, they would have had to sign some kind of guarantee to that. So it's going to look at a marriage, and you're going to look at the state where they live. In some states, they allow what's called common law marriage, and there are different factors, and they look at the fact that they live together and they intend to be married and they hold themselves out as spouses. In those cases, even though they might not technically be married, the state they consider them married. So you could look at and determine if that state allows for common law marriage. But if they're not married, if they're just living together, then the only way to be on the hook is if they sign some kind of financial guarantee form. So good questions. Good questions. Okay, now I'm going to move on to some of the more meaty issues. Basically, I'm going to talk about wrongful delays. This happens quite a bit. I found even with regardless of claims are submitted electronically or paper. I know with many of our clients, it's about 65-35 as far as how claims are submitted. About 65% goes electronically for most of our clients, and 35 on paper. And I hear daily, I get told about, Joe, what can I do? I've got claims, some of them, even if they're submitted electronically, they're still delayed. I need my money, but it could be, this is just examples that are common that come up for us frequently. High balance review or medical review or what have you. A claim shuffle, as we said, the home plan and the local plan. And a couple things that I look at here that I recommend. Again, today, some of the things I'm going to talk about are just tools and tips that we've seen and that my staff has seen from our perspective. Some of the things aren't going to work every single time, but it's at least one of those things that I tell my staff that if you don't ask, you won't get it. At least if you raise the issue, push the issue, you're going to get it more times than if you never raised it at all. So a couple things to look at here real quick is it involves an issue called preemption as to whether or not state statutes or other statutes may apply as opposed to maybe contract or something else. A couple different kinds of plans out there. Obviously, fully funded plans. We've got a fully funded plan at my office, basically, where the office pays premiums for the employee to, say, an Aetna or Blue Cross or Cigna. And you also could have fully funded, that's fully funded, self-funded plans, or where the employer basically has decided to pay the medical care and treatment of their employees out of their own pocketbook to self-fund that. Many of those choose then to get a reinsurer to kind of kick in stop loss coverage after a certain stop loss amount is met to kick in and come to the table with the rest. But that distinction can be important. I don't see as many self-funded plans as I used to. I used to see a lot more, but they're still around and there's still this distinction. Here's why this is important. For a fully funded plan, you're going to have the advantage, in addition to possibly a managed care contract, maybe some state insurance laws, state prompt pay stage. And that's important. If you have a self-funded plan where the business chooses to fund those out of its own pocket and then possibly have a reinsurer, that's important because under the doctrine of preemption, the federal ERISA statute is going to trump, it's going to preempt any state statutes. So you may have some cases where the state statute I'm going to talk about in Jersey, some of the state statutes just won't apply. So it really depends on what the plan is. So these, I'll go over briefly, I don't want to run on over time, with ERISA. There are some time frames between initial benefit decision, 3 days of data claim, and time frame from decision on appeals. I'll bring this up if I can talk about it. I don't want to waste a lot of time because time is limited. These are decent time frames to keep in mind, but what I don't like about them is they don't have teeth. There's really nothing just under these time frames that happens if they're not met. They don't have teeth, so to speak. Two things that I look for here. These are New Jersey, but again, most states have some type of a prompt pay statute. You need to look again at where the patient resides. They can be treated here, but reside in a different state. New Jersey has two things that I look at. The most important thing in a prompt pay provision, either in a state statute or in a managed care contract, you can have them there too, are number one, a penalty. I always look for some kind of penalty. You want some teeth about what happens if these aren't paid on time. So, here in a decent time frame. So in New Jersey, basically, once you get a clean claim for electronic, 30 days after it was received, and for non-electronic, 40 days. Those are good time frames. Some states that I've seen that do have these provisions have much more extended time frames, 45 days or 60, even for electronic. So these time frames are really good. And the penalty is good. The penalty is 12% per annum interest. That's in addition to the amount owed under the claim. So this is really important to keep in mind. This is a tool that your staff could use for you providers out there about, for the fully funded plans, there are time frames here. Also, you're going to have the potential of managed care contract time frames. Sometimes they're silent, but many times you're going to have a time frame in the managed care contract that has a time and a penalty as well. Some contracts, they don't as much, but some actually used to have a penalty that gets the whole discount revoked. Nice to see those. I don't see those as much anymore. But keep that in mind. Some states also have a provision that says if there's a managed care contract that's at play, this could be a patient in a different state, if the managed care contract has a worse time frame, a longer time frame than the state allows, that you have to follow the state statute. So there's some state provisions that do address that. But keep that in mind. It's a good tool to have for claims that fall under a self-funded employer. You're going to want to really look at the managed care agreement because the state statute won't be applicable to those. Workers' compensation, again, they've got a statute. I'd like to see more. Here they talked about basically payment being reasonable. More of a usual customer. I know with some of our New Jersey clients, they like to see 90 cents on the dollar. I know other clients that differed on that. At least we've got a statute here, but it doesn't have some of the things that I look for. I like to see basically a time frame that's laid out. They don't have a time frame, and I like to see that there. But some states do have that. Again, like I said, keep that in mind because you're going to have folks that could be from other states that are treated, and some states have a workers' compensation, workers' comp statute that that looks like the insurance statute here is going to have a time frame. All right. There's a couple. I won't read over all these, but there's a couple practices that we've seen. When you're talking to a rep, I always have my staff ask them, especially for claims that are submitted, with a paper trail that might not take time for to verify from the rep. When was the claim received? Get the rep's name. Always try to get their last initial at least to find out, because you call back 2 weeks later and they might be, I'm sorry, we don't have it on file. So you want to get that kind of information. Sometimes with staff, what I ask them to do is they deny receipt of it, get a fax number. Sometimes they'll tell you that HIPAA does not allow for faxes to be sent with PHI, and that's not correct. There's nothing in HIPAA that prohibits that. There should be appropriate safeguards. Fax in a certain place, they should be safeguards in place to protect that PHI. But HIPAA does not prevent fax. That's an excuse. So I usually have my staff ask it, in this case, hey, what's your fax number? I'm going to fax it to you. You trot over there and get it, confirm that you've got it. And that doesn't work all the time. Sometimes they refuse, but again, if you don't ask for it, you won't get it. Reinsurance as well. I did mention that. That's one of the things that's important. If you do have a claim, we've seen these. I used to see them a lot more, but I still see them now, where you're told that, I'm sorry, the delay is because it's with the reinsurer. The employer might, it's a self-funded employer, and they might have paid their stop loss amount. That might be, say, $5,000. And say, hey, the rest of the claim is with the reinsurer, and I'm sorry, it's going to take a while, which there's not much I can do. And in those cases, what I generally ask for is the reinsurance information. Who's the reinsurer? Who's the contact? What's their name and number? Who can you deal with? So you can then follow up with them. Again, they don't always provide that, but it's worth asking for it. And then you can also go back to the employer. Remember, if they choose to become self-funded, the employer's on the hook if the reinsurer doesn't come to the table. And then finally, the statutory language is important. This is a nice area because you've got some different tools. You have potential statutory language. I should have also added in the contractual language. Many managed care contracts are going to have time frames. Know what those are, and they know what the penalties are as well if they've got those. We'll keep going. I'm not going to spend a lot of time on this. I'm happy to talk to folks after just in the interest of time, but something that we usually go over that's usual and customary denial, and find those. Misverification of benefits or misquote. I'll spend just a little time on it because in practice I still see this come up. It's still good law, and I still get clients that ask me about it. The scenario here, and again, we're talking about verification of benefits, which is different than prior authorization to treat. We're talking about two different things. With this case here, and it's going to be a non-emergent situation, so I'll explain why in a minute, but basically the patient needs to come in for some elective work, non-emergent. And before they do that, the healthcare provider contacts their insurance carrier just to verify coverage. They want to see, is there coverage in place? Number one, does it exist? And then number two, what's the extent of that coverage? Because they want to make sure that it's okay with them. Because if not, if there is no coverage, or if the extent of coverage isn't too good, then simply there could be other arrangements made. And that's why this can't happen. And in emergent situations, it could be a violation of PALA. Because in this case here, if it's elective, you could make other arrangements. Away, you could maybe do a promissory note or something like that. But they want to check ahead of time just to see what that coverage is and what the extent of it is. And the issue comes about when the hospital calls in and they're told by the insurance rep, yep, there is coverage, they've got coverage with Cigna, and here's the extent of the coverage, here are the limitations. The hospital says, all right, based on what you told me, I'm going to rely on that. I'm calling you to get that information because I don't have it. I'm trying to get you to turn over the information so I can decide what to do. The hospital makes a decision to go ahead and treat the patient and do it. And in this case here, lo and behold, they provided the valuable medical service treatment that would bill Cigna. Cigna says, I'm sorry, there's actually no coverage. Claim denied. That's an issue because in this case here, basically when the hospital is contacting the payer to find out if there's coverage, find out if there is, what the extent of it is, and if there's any limitations. At that stage, basically, the payer is making a promise to the hospital, and the hospital relies on that. Because, again, like I said, had they known that there was no coverage, the extent wasn't very good, there were a lot of limitations or maximums that had been met, then they could potentially have made other arrangements. So that's, and it's called promissory estoppel. You've got a promise, the hospital relies on it, and now try to prevent them from backing out on it. And that's important because you, question, okay, ma'am? Go ahead.
Now they all have to explain right. Yeah, telling you this,
right.
Don't hold it to a promise.
Right. That timer is. Did you have the same question?
No, more about when you bring in your insurance plan to be purchased off the exchange. The insurance companies can't access coverage, so they have to make payments on premium.
Right.
So yes, on the day they came in, they said 60 days behind on their premium, and I called and the insurance company said that they do not cover.
Right.
But the insurance company doesn't have to make payments on the premium, so the premium pays that month.
Right.
So they don't make payment on it. Effectively on that day, their insurance has to terminate.
Right.
Right.
No, and I'll address those of you. That's a good question. I haven't had any of these yet regarding the exchanges where that happened. I would still press them and say, hey, you made this promise, we're allowing it. And in worst case scenario, it might get you a negotiated resolution or settlement. It's a good question. I haven't had that arise yet with the exchanges. As far as the disclaimer, that's basically what I call pure boilerplate. I was going to say pure something else. That's what I was thinking. It's boilerplate, and that's actually come up in cases where I've litigated and litigated with clients, and that has not been upheld at this time. But we've actually won those and gone above and beyond the disclaimer. So you're not going to win all of them, but it's still worth pushing. Just to give you a real quick example, I don't want to run out of time, but this is good law. Just real quick, an example on how this works. We had a case here where a gentleman came in for some elective work, and basically he was going to have some elective work done, and he came in to fill out the information, and the hospital did provided a really good verification of benefits, they got the extent, et cetera. And in this case here, basically after the patient was discharged and they got billed, they found out, okay, there was coverage, but there was a maximum, a lifetime and an annual maximum, and both those have been met. So I'm sorry, I'm not going to pay it. But in this case, what happened is our client actually asked the right questions. They went through the health and data, a checklist. So they not only verified if there was coverage, but they verified the extent of it. And they specifically asked if there were any annual or lifetime maximums. And in this case, they said no, unlimited. And in that case, real quick, I'll say we actually had to take that to the court. And in that case, since they verified, they made a mistake. When they verified that there were no limitations, the hospital relied on that, they actually got paid.
Well, what do you need to document?
Right. Normally what we did in that case, that's a good question. We actually came up with a checklist. Would write down who you called, the number that you called, who you spoke to, always try to get at least the last initial, the date and the time, and you went through questions, whether there was coverage, if there is, who is it, what the extent of coverage is, and then there are questions about maximums, and in those they filled in the blanks and they find it. And that's what we use. Good question. Yeah. Sorry? Yes, sir. Sorry, you had one? Right there.
Now, first, if I'm wrong, but if the Affordable Care Act is not wrong,
what's that?
with the Affordable Care Act, there's no law maximum.
Right. I've seen them in some cases in some of the grandfather plans. Is what I'm saying.
And the second question is, when you have to use the file, get into the insurer from the employer. So that's where you ask the coverage, they say you have coverage.
Right.
Then there's certified and trying to find out that kind of coverage on the call.
Right.
So the commissary has to fulfill.
Yes, it can, because what we've had in some cases is there have been some delays sometimes in getting information. What we've seen court hold is they basically said in today's age, with email, electronic transmission, there's really no excuse for this delay. So I would still argue that it's still applied. Yes, ma'am.
What if
Right.
like 2 days into the day, they're covered again? Do they have to take the end of
It depends. So in that case, you're really not going to have this argument. So, you might not have, I guess in that case, you might not have the full argument. The answer is it depends, because in that case, you're going to have to take a look at the policy and see what it does. There might be other coverage pickup that could then be liable. You're really going to have to look at the policy in that case. But the answer is it depends. So, yes, ma'am.
And they also tell you that they want to figure out right.
So they don't want to say that, but anyway, what I was going to say is we report all of their patients. And we get as much as we can online, screen straight to save time. So if we report it, we'll get a legal translation of that.
That's a good idea. It's good to make sure you keep the recordings, because I had a client that did that and then they decided cost saving, I'm not sure how it's saving cost. They didn't want to keep the recordings over, a certain period of time, very short period of time. They had them all lapse. I'm going to go ahead. I haven't seen a lot of COBRA. I'll go ahead and answer questions about it later, just in the interest of time. A couple other issues that I did want to go over. The important thing about COBRA, I know it's still, it's still out there. I don't see many issues come up from my side. But one thing I always like to require, or basically remind clients about is, once it's elected, number one, want to make sure that the notice is notification by first class mail, the last known address. I've seen it just handed to the patient and exit interview. It's got to be sent by first class mail, and anyone can pay the premium. Sometimes it's a cost benefit analysis. It's going to be a larger premium, but even the hospital could pay the premium. I won't spend too much time on that. I know there's some other topics. Keep going. All right, next two I want to talk about are combine them, basically together: medical necessity and prior authorization. These two go hand in hand. With medical necessity, there's a case recently. I'll read this quote that I liked it because it describes medical necessity. In the case I read that medical necessity is both a component of the relationship between the hospital and its patient, and also a specified requirement for coverage and insurance plans. In practical matter here, if treatment is not medically necessary, the patient's not going to be responsible for it. The insurance company isn't going to pay for it. So in these cases, one of the things that's very important here is the medical documentation. That's one thing that we've got UR nurses that work with our attorneys, and the medical documentation is really important. And one thing that I see that our clients talk about, and I heard in one of the sessions yesterday, really important, if possible, that the physicians, the doctors, don't cut and paste. Sometimes they have notes that they do not even cut and paste patient, and that can really hurt your feels in this area. Two areas I've seen with medical necessity that come up a lot. One is just basically an outright denial. They say this patient had back surgery, we didn't do anything regarding potentially less conservative methods, so we're outright going to deny that. Other ones are like this, where it involves a level, basically a level of care. Somebody's been a little longer than the insurance company thought that they should be. And this is one of the things here. I actually got this language here. One of our attorneys that works with me talks about medical standards, and he uses this phrase about how it needs to be consistent with generally accepted standards of clinical practice. And again, it's really, really important to get your clinical folks involved here. You want to have good documentation, not notes that are, cut and pasted. And you want to have, when you do appeals, it's important to get your clinical folks, clinicians, and your case management folks involved. One thing I have seen when these cases go to the legal side, construal in favor of coverage for the patient. You want to try to be able to find coverage for the patient to find out that this treatment was medically necessary. A couple tools here, and again, I just want to get through a lot of material, so I'm sorry I'm rushing, but so I could slow down if you need. Some things that I've seen from my perspective here, basically in addition to having your clinical folks involved, is basically using some of the tools available. Yeah, basically, by that I'm talking about interqual. I have clients that it's kind of split between the Norman Care Guidelines and interqual, and both of these have really solid criteria for making this medical necessity. determination. I don't think it matters which one you use, but they both have really good factors that could be used to do appeals. Few reasons here. I mean, I know that there's a lot, but this comes up a lot. Obviously, there's certain appropriate reasons for medical necessity, especially in the level of care. Inappropriate reasons. I do see a lot of cases talks about writing notes that, you know, they want to wait until Monday. The patient's not ready to go. Family doesn't want them to leave yet. Those are not going to be valid. They won't be medically necessary and appropriate reasons. Oh, yeah.
And they say, I don't want to go to that nursing home. I want to wait till the end of the day.
Yeah, you're right. You're right. Yeah, that's not going to be. It's basically the same instance as patient not ready. So that's kind of the global reason that whatever it is, they're not ready for this case. Yeah, I would. That's not going to be deemed to be medically. Yeah. In my opinion, that's not going to be deemed to be medically necessary. Yes, sir.
The difference for us is looking at the formula. And they use it to fall, but it needs to run that period, but doesn't need it to fall. Right. They often want up. Okay. Will that stand up on the patient? If you say we get in their life, therefore they want to wasn't.
Neither one of those, Interqual or Millman, neither really have the supportive law. They're not something like a court case that's going to be binding. And I would certainly argue they're both standards that are, you know, accepted. They both have best practice standards. I haven't really seen cases like that, but I would say if one only says I use Millman as opposed to Interqual, I know that would hold up. If you have a case that meets one of those, I think both of those are equally acceptable. And I've got clients that just choose to use one and some the other, but I haven't seen a case like that. But honestly, I don't think you could just say, I'm going to use Millman only and not Interqual, and if it means Interqual and not Millman, I'm not going to go by it.
What's going to happen with Charles Biden's law? And that's what we don't
Right.
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 It just that's called Millman, but when the people out and
right.
It doesn't get problem.
And I'd appeal that and say, just because you use this one and you're used to it, I'd use that and I'd get, you know, clinical documentation back up and say, this is equally as reliable as a lot of evidence out there that both are generally accepted standards. And I'd use that and say, this is just as acceptable and it meets the criteria, but I would still push that and say, this is medically necessary. Good question, though. Good question. Again, I won't go over all this in detail and just read it all, but what's important here, two things here that I find important. The specific reason is very important. You want to find out why the payer deems the treatment to not be medically necessary. What the level of care, what is the issue? You don't want to just hear medically necessary, or was it medically necessary, you're going to deny it. You want to find out what criteria they use, what exactly was it medically necessary about it. And the appeal, sometimes you might be limited to one appeal by contract, but if you have it, I encourage an appeal more than once. Probably going to get you a different reviewer, and we've been very successful at getting different results at appealing multiple times. Okay. So with pre-authorization, I'm going to tie the two of these together. This is what I call a creature of contract. Authorization is normally going to be required by contract, either the policy itself or a managed care agreement. And in a nutshell here, this is just one of kind of a common scenario with the cartoon, but you've got a case here where hospital knows it's got to get authorization. They try to call the payer, and they can't get through, or they leave a message, and nobody calls back. So the key here is obviously it's contractually driven, and it's important to know what the contract requirements are and to try to meet those. But there are going to be some cases, again, two things here I'll talk about, where the contract requirements can't be met. So a couple things to look at here. And remember, with state statutes, like we talked about from the beginning, with the state statute, what's the kind of plan the state statute won't apply to the self-funded plan. But you do have some time frames here about when the payer has to get back to the hospital. In the New Jersey statute, either 15 to 24 hours for hospital or ED services when they're in. And if they fail to respond, it's basically going to be deemed to have approved that. That's actually a pretty good statute. Also, some contracts will have some language like this. It's important to know what the different protections are in the contract. One thing that I do and that my staff does in these cases, if the contractual requirements aren't met, if you didn't get prior authorization for some reason, it's important to show that you know you have that obligation, that you understand it. And so I call these mitigating factors for the appeals. That you're going to have a variety of reasons. It could be try to get a hold of the payer, didn't respond, to let the message, they didn't call back, they couldn't get a hold of the payer. It could be that the patient came in and said that this was work-related, and it turned out it wasn't work-related, and they didn't know about the healthcare payer until later. Or the patient came in with the card for the healthcare payer they had 2 years ago. Whatever reasoning there was, there's hopefully going to be some kind of mitigating factor here, and you want to be able to use that in the appeal. And in an appeal, what I encourage my staff to basically the most successful appeals are those where you acknowledge that you know of this contract, right? You got to be sure that you say, I know it's a contract requirement. I acknowledge we have this requirement, but in this case, I couldn't meet it, and here's why. Talk about whatever the mitigating factors are. It's important to lay those out. And then I also ask for a retroactive authorization at this point to show that had we been able to get a hold of you, when we called or left a message, you would have approved the treatment. It was medically necessary. If we've been able to get a hold of you ahead of time, you would have approved it. So I say at this point, since you would have approved it, it's medically necessary, you're not going to be harmed, go ahead and grant retroactive authorization.
Can you go back
Oh,
to
yeah, sorry. No, I'm sorry.
you got on the last line? I heard this on the last revenue.
Yes, ma'am.
So what we try to do is audit our total the next day.
Right,
We're going to
right.
take off and
Mhm.
make sure the cervical cancer is, if the doctor finished the dissertation or
Right.
operating for it, we
Right.
try to include
Right.
you may not have all the changes.
Right.
And therefore, it's beyond the 48-hour window. So we're still trying to argue, if the surgeon is approved for me, we didn't go after the elbow, they still did research.
Right,
And
right.
so, so we end up really trying to fight that,
Right. And I think you've got a good argument. Say, look, here's what we did. It was medically necessary. If we had this information, we would have authorized it, and so I'm asking you to do that now. Now, the only other thing I've seen in some of those cases, sometimes in certain physicians that are habitually late, they never get anything in on time, and that might be one of those where you've got to talk to the physician to see if they can speed this up a little bit. And I don't know if that's possible or not, but
that was the issue. They won't give you an offer. The application,
right,
the lady,
right.
won't give it with that procedure that, they're
right.
planning on doing. But, I was doing that one where myself was in the video.
Right.
Well, you couldn't do that if he's operating in that area.
Exactly.
And they were given.
And I still push that and sometimes bring up the practice once you assist. You really want to have to take this patient, go back in again just to get the cyst. That's going to be a lot more expensive on the patient. But there's a lot of common sense that comes into play sometimes. It's a good question. Just a couple more things I'll go through with this. I bring it up because it still happens. This is the opposite of what we've been talking about. We've been talking about trying to get the payers to pay the hospital and the healthcare provider. Here, it's paid, and they're going to come back later at some point and say, I'm sorry, I paid in error. I want the money back. Basically here, the one thing that I would say is that I tell my clients, don't automatically refund the money. I have too many clients that they get a letter requesting a refund, they write a check. So in these cases, do not automatically refund the money. A couple things here that are important. New Jersey, there's a good statute. Not every state has this. One of the better ones I've seen. So you have a certain time frame. And again, just keep in mind, state statute won't apply to self-funding plans, but others it will. You've got a time frame. They can't go back indefinitely. Thank you. They can't go back indefinitely to request a refund. And basically, they've got a hold period. Within 45 days, they can't continue to collect. But the provider's only got a certain amount of time to contest that. A couple of quick things with refunds. Obviously, don't just automatically refund it. And the contract may discuss it if the contract provides a provision about what to do in case where there's a refund. Kind of need to follow that. But in many cases here, real quick, what I look at is two things. I make sure that I find out the client has, first of all, received more money than they should have. Did they receive more, say, the bill charges of more money they should have on the case? And then secondly, it's called unjust enrichment. The second thing is, do they have clean hands? And that means, do they know of any reason why they shouldn't have been paid? A good example of that is we're talking in the misverification benefit. Let's say there's a case where they contact the payer ahead of time to say their benefit. The payer says, no, they're earning. So you know ahead of time you're not going to get paid. In that case, you might have to get the money back. But as a general rule, outside of contract, if you didn't get paid more than you should have, and you don't know of any reason that you should have gotten paid, then there's a good likelihood you can hang on to the money. And then we're not talking about government payers. We've already got a government, I'm sorry. Okay, good question. Let me address that real quick, and I'll go for 4 quick things. With offsets, we had that exact question, where one of our clients got a letter from Blue Cross, one of the Blues, basically said, here's our refund demand, and it was big. It was almost $1 million. And they said they're going to give them 7 days to pay that back. They said, if you don't pay it back, we're going to offset that amount on all these other claims. What we did in that case was, as high up as we can, we went through some private relations talks and said, hey, hold off on this. If you offset these claims, we're going to consider that to be bad faith. Those are claims that need to be paid, and we believe we have a good reason why this money shouldn't be refunded. And we actually got them to work with us. And it was good we did, because by the time we worked through the whole case, there was only about 1/10 of that to be owed. So with the offset, I try to get involved quickly and go up and say, wait a minute, those are claims that should be paid, and we have a reason for basically refusing this refund request, so give us time to work through that. Good question, though. Real quick, 2 other things. Policy exclusion. It's important to look at the fine print and not just think, okay, it's excluded, we're done. This is the case here. They changed the policy after this, but so this is the true case we had. The client was a woman attempted to shoot herself in the stomach, went in, she survived, the hospital did a wonderful job, left behind a medical bill of about, I think, between $800,000 and $900,000. The payer said, I'm sorry, that's a self-inflicted injury, I'm not going to pay it. So we got the policy and we looked at it. Normally it just talks about self-inflicted injuries not being covered, period. This one had an additional provision that not covered unless the injury is a result of an underlying medical condition. Well, it was. She's been treated for depression, antidepressants, a lot of different medication, and we actually pushed back and we got that claim paid. Hospital got $800,000 plus. The insurance company changed their policy. That line is gone now. But it's important to look at the fine print. Like, I can't do it like that. Client sale, policy exclusion, we're done. But look at the fine print. Get somebody to look at the fine print. And then real quick, too, I think I know I only have, I got a couple minutes left. 5 minutes. Okay. Last thing I want to talk about are motor vehicle accident, third-party liability cases. Just a couple quick ones. Jersey's got a hospital lien statute, which is good. A lot of states don't have any. And I will say real quick, you guys are on the ball, so I know you know this is going to be elementary, but we're talking a hospital lien that is state statute driven. Some states have them, some don't. I'm not talking about a judgment lien or a lien on property. I had a client in one of these MBA cases try to get a lien on somebody's property. There's only certain instances in certain states that allow you to do that. Here, we're talking about a hospital lien. Just put the hospital in line for payment with the other creditors that are going to be paid out of that liability settlement. The notice here is tight. So if you're going to file a hospital lien notice, it's within 90 days of the first treatment, and then notice after that's filed with the clerk, and you've got to let the necessary parties know, I think, within 10 days after that. A couple things that are important in the MBA cases, the TPL cases. New Jersey does have a good, it's in one of 12 or 13 no-fault states in the country. So you've got PIP coverage potentially for claims. Some people have the minimum, and some go up a lot more than that. That's a really good avenue to try to get in and get your payment. That's important. I like the states that have the no-fault PIP coverage. Again, it depends on the state where the patient lives. Some states are no-fault PIP coverage, some aren't. Even in states where they don't have PIP coverage, a couple other things to look at is medical payment coverage. Some states allow up to $5,000, $10,000, $15,000 in medical payment coverage. That goes fast. They'll find out if they have it. Obviously, health insurance and maybe getting a subrogation agreement to get health insurer to, in those cases, to pay. And then finally, with hospital liens, sometimes if you can get the other avenues of payment to release payment, you might not have to file these, or you might want to get one on file since you only have 90 days and you can amend it. But up front, accident details are important. What happened, where it occurred, things like that. Getting the relevant policy information and make sure you have that before filing the liens. The other thing too, real quick, are letters of protection. Clients ask me about this a lot. This is basically a letter you're going to get, and they exist around the country from a patient's attorney to say, we'll protect your interests. Please don't go after my client while this is going on. Those aren't always worth a whole lot, so scrutinize those. I'm not a fan. Not a real fan of them, so you don't have to sign them, but bring that out. A couple minutes left. Good question. And anything else? I'm happy to hang around. I'm sorry I rushed through a lot of that. I had a lot of information I wanted to go over, just to give you some, try to give you some pointers of things that we've seen, that my staff has seen for our clients. The landscape has changed even under the the Affordable Care Act. You've got a lot more folks that are covered, still going to have some of the same issues that come up with insurance. And with the high deductible plans, you're going to have more issues with self-pay and bad debt, and also potentially some of the parental spousal liability, things like that. But yes, sir.
We bill somebody, and then payer comes back to the detailed medical records. They do it in whatever 2 weeks or whatever. Then I get any reports.
Yeah, I mean, did you when you billed them, was anything else provided? What was provided when the claim was billed? Just normal. Right. Yeah, I'd say. I mean, it depends. I always think it's worth pushing back. If you build the claim and if you did send them the information, maybe it wasn't timely. Maybe it was just a few, not too long after the time frame. Absolutely, I would always push back. Yeah. Yes, ma'am.
We had a patient who was living in his daughter's house. His daughter's car got in an accident.
Right.
Patient ended up passing away, and the insurance company gave the daughter his time saying that he used his car insurance, and she refused to sign it.
Okay.
And they won't give it back.
Any idea what the form? Why they needed that form? I mean, sometimes there are reasons to to get around the form. Again, right. 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 Good questions. Good questions. Anything else? All right. Thank you, everybody. I'll let you get